Thank you. For those who may not know me, I'm Jonathan Cole, the Provost and Dean of Faculties at Columbia, and I want to welcome you to this second in the series of debates. Today, George Fletcher, the Cardozo Professor of Jurisprudence at Columbia, will debate Judge Richard Posner of the Court of Appeals, 7th Circuit, and Senior Lecturer at the University of Chicago. The topic is, as you know, the rights and wrongs of going to war. I want particularly to welcome back to Columbia our guest, Judge Posner. Before moving to the main event, I want and feel the need to use this important occasion to repeat a number of observations that I made at the first debate and to add one additional thought. Over the last year, since the tragic events of 9/11 and the close on its heels passage of the USA Patriot Act and subsequent events, I've been struck by and dismayed at the near-deafening silence on the great university campuses of the expected voices of dissent and by the absence of a sustained debate over the fundamental issues in tension, the balancing act, if you will, between the needs for national security and the protection of basic individual constitutional liberties. In light of arrests of citizens and non-citizens who have been detained for months without access to legal counsel, without the filing of formal charges, without the ability to see family, without access to civilian courts, I'm surprised, quite frankly, by the few debates on college and university campuses on governmental policies that have led to these abridgments of core rights. I'm concerned by the limited imagination of those who fail to think that there but for the grace of God go I, or members of their immediate family. I find more often the expression of belief that since I'm not guilty of anything that could be deemed illegal, I have nothing to worry about. And therefore, I should not be concerned about what the government might do to others in the name of fighting terrorism. In fact, things are beginning to get nasty out there. Websites are being constructed to identify professors who are supposedly advocating anti-American or anti-other positions in their speech or written work. Invited talks are being canceled because of the content of a speaker's prior political views, speech that may in fact be repugnant to the overwhelming majority of people. Petitions are being crafted to support or oppose economic sanctions on nations involved in conflict and controversy. Alumni are beginning to email us by the hundreds to suggest or assert that specific members of the faculty with views they find obnoxious should be sanctioned or fired by the university for their political views. Others are ganging up trying to prevent highly respected scholars from being hired because of their political views and legal activities outside the classroom. A great deal of this activity is not based on knowledge, but on ideology and emotion. Emotions derived from limited information from which spurious inferences are drawn. There is too much ideology in the marketplace, too little effort to broaden the base of knowledge from which to develop strong personal views. The climate is changing. And now it is the time for us to be part of an effort to redirect our energy away from these forms of activities to open civil debate over the critical issues that lie behind these expressed passions and beliefs. Now is the time for university leaders to demonstrate their mettle by openly defending the right to speak, even if the content may be repugnant to a majority of listeners. Now is the time to preserve and reinforce the unique feature of great universities as places where open, unfettered exchanges of ideas can and must take place without fear of retribution, and where those ideas will not be silenced by the powerful or the wealthy. Now is the time to test our tolerance. Now is the time for us, for those of us who are part of groups that have historically been persecuted because of what they were or what they said, to be brave in the face of criticism and to reinforce the idea of open discourse among people who may seem to pose a danger to us. It would be ironic if a minority people, my people, who have suffered for thousands of years because of who they are and what they have said or believed, was to become the force preventing speech and denying opportunities to people who are, perhaps, expressing views that they find repugnant. Now is the most important time for the university to defend these fundamental rights and the soul of the university, not when there are no individuals in the academy under attack for their ideas. Now, I'm particularly concerned that so few members of the tenured faculty, except for the usual suspects, here and at other great research universities, are writing about or publicly debating these issues that would seem to lie at the center of what we identify as hallmarks of a democratic society. There is little detailed debate over what we mean by the ambiguous category referred to as terrorism, little discussion about the difference between war versus criminal behavior and the implications of these distinctions for how people are treated under fundamentally different codes of justice, little conversation over the use of various means such as coercion or torture in the name of ambiguous ends, little debate of whether we are witnessing a perfection, if you will, of McCarthyism. What is tenure for if not to protect our faculties from assault and retaliation in times that call for, indeed requires, open national debate and tolerance of unpopular views? As Columbia's chief academic officer, I receive demands from time to time, and recently, and in some cases more often, for the dismissal of a member of our tenured faculty who has expressed unpopular and controversial opinions. It has been my duty and pleasure to respond to those hostile critics, those who do not understand that the essence of a university is in it being a place where faculty can speak out and express unpopular views on difficult issues, and defend those voices regardless whether they represent the left or right in the name of academic freedom and tenure. I want to be able to do this more often these days, for if tenured faculty fail to speak out at times like these, when they do hold definite views, regardless of their political position, our students and other colleagues are denied a critically important educational experience. Our universities fail to fulfill one of their important functions, and our democracy loses the public discourse that must take place to inform better its citizens. What is tenure for, and why should we keep having it if we fail to use its protections at moments like this? I have a set of hypotheses for why there has been less open debate among those who have protection of tenure, but this, again, is not the place or time to elaborate on that. It may fall, in fact, particularly to the tenured faculty to engage in this debate. While presidents and provosts must set out and reinforce basic principles that guide a university, its tenured faculty must debate the content of disputes. For if presidents or provosts take very strong positions on content, even if they claim the impossible, that is, that they speak as an individual, not in their role as head of the university or chief academic officer, it can have a very chilling effect on open debate within the university community. Now, certainly we have with us today two individuals who have no fear of speaking out on the issues to which I referred to, as well as others. I applaud them, regardless of whether or not I agree with them, because they help to move the national debate along. Both George and Judge Posner are prolific authors who engage in debate on the most important political, social, and economic issues of our day. With great expectations, I will join you in listening to what they have to say to each other and to us this afternoon. We are fortunate also to have with us today two very distinguished legal scholars. Professor Laurie Damrosch, the Henry L. Moses Professor of Law and International Organization, will be our moderator today, and Professor Catherine A. McKinnon, who is visiting Columbia this year, and who I welcome also, from the University of Michigan, will act as our interlocutor. Again, I'm very pleased that you're here with us this afternoon, and I turn matters over to Professor Damrosch. Thank you.
Thank you. This is my first time to speak in this configuration, and I see I cannot make eye contact with all of you, but I hope that you can hear me. And if any of the audio is not working, I was in a lecture here a few weeks ago, and there was a whole dead spot back there, so alert us if you can't hear. Okay, our topic is the rights and wrongs of going to war, including restrictions on civil liberties. We have two principal presenters and a third interlocutor who are going to give us different perspectives, not just on what they think is right and wrong about a particular choice or set of choices that are facing our country and the world, but more broadly on ways to think about right and wrong, or to think about rights and wrongs. These are three leading public intellectuals. They generate ideas in a university setting, and then they bring those ideas to very large audiences, including this one. They're prolific writers of scholarly books and of shorter opinion pieces, and they're certainly gifted debaters. So I'll begin with Judge Professor Richard Posner. He's the Chief Judge of the Seventh Circuit Court of Appeals in Chicago. He retains a connection with the University of Chicago Law School, where he was a member of the full-time faculty for many years. And maybe that's still his day job, and the judgeship may be something he does on the side. I'm not sure. This is the man who invented the 48-hour day, I guess. I don't know. Anyway, he's one of the originators and the most prolific scholars of the intellectual movement known as law and economics, and he has applied the tools of law and economic analysis to many topics, not just the obvious ones like contract law, but also such relatively non-economic topics as law and literature or sexuality. His book about the Clinton impeachment and affair of state drew critical acclaim and a wide readership. He has a book on the 2000 election, and he has a book called Public Intellectuals, which you can buy outside for $30. And he's going to talk to us about the rights and wrongs of going to war, including restrictions on civil liberties. I think he'll be emphasizing the civil liberties part of that topic. I imagine he might stay away from specific cases that are or might be pending in the courts of the Seventh Circuit, but I don't know. He's pushed the envelope in various ways, so we'll see. He will be followed by Professor George Fletcher, who's the Benjamin Cardozo Professor of Jurisprudence at Columbia. Like Judge Posner, Professor Fletcher is a polymath. He has made his mark across several fields of the law. These include criminal law, torts, and legal philosophy. His last two of many books are directly relevant to today's topic. He has a book called Our Secret Constitution, How Lincoln Redefined American Democracy. That was published last year. And he has just published a book called Romantics at War, Glory and Guilt in the Age of Terrorism, and you can buy it outside for $25. we will see how law and economics works in today's market. Now, Professor Fletcher's previous book on the Bernard Goetz case, A Crime of Self-Defense, is a probing look at a problem in domestic law with very plausible analogies to some of the claims of rights and wrongs of going to war today. When is it lawful to pull a trigger because you suspect someone may be getting ready to attack you? What is relevant about the state of mind of either the guys with the sharpened screwdrivers or the guy with the gun, or maybe the guys who might or might not have weapons of mass destruction? So he may draw on a few of those analogies. After our two principal presenters speak, the interlocutor will be Professor Catherine McKinnon, who, as the provost said, is visiting at Columbia from Michigan, where she's the Elizabeth A. Long Professor. She is an original thinker on feminist legal theory and the author of several acclaimed books on feminist topics, including on sexual harassment and pornography. But especially for purposes of today's discussion, I'd like to mention her major work, Toward a Feminist Theory of the State. She's labored hard on behalf of the victims of war, especially as counsel for the Bosnian and Croatian women who've been seeking redress for atrocities committed against them in the Yugoslav conflicts. She successfully sued Radovan Karadzic in federal district court for those atrocities and won a multi-million-dollar judgment against him. And here at Columbia, where she's visiting this year, she's teaching, among other things, a seminar called On the Law of September 11th. Now, for the format of our presentations today, we're going to give about 8 minutes to each of the principal presenters. Old habits die hard. Judge Posner will go first, then Professor Fletcher for about 8 minutes apiece. Then they'll have an opportunity to rebut each other for 3 or 4 minutes. Then we'll have questions from Professor McKinnon as the interlocutor, and a little dialogue. If we run out of things to say, I might toss in a question or two, and then if I run out of things to say, we will then turn to your questions for the remainder of the time, and I think we can go till about 5:30. Okay. So, without further ado, I'll turn the microphone to Judge Posner.
Well, I will not be undersold, so if you go outside and offer $24.95 for my book, I'm sure that'll be fine. But I want to thank Professor Damarash and Professor Cole for their introductions and say how pleased I am to be here and have this opportunity to debate with Professor Fletcher. We first debated at a conference on the legal response to international terrorism that was held here at NYU in February. And that's when I called Professor Fletcher a legal theologian. a term that he embraced, to my surprise. And he has since expanded on the views he expressed at this conference in the book that Professor Damers mentioned, Romantics at War. A little overpriced, perhaps, but it can be recommended anyway. And I have expanded my views in a chapter of a forthcoming book called Law, Pragmatism, and Democracy. And there are many differences between Professor Fletcher and me on various points of detail, and I'm sure political differences and so on. But actually, the most interesting difference, I think, especially for this audience, is a difference in jurisprudential stances. And it's the difference between legal formalism, of which Professor Fletcher is a distinguished exponent, and legal pragmatism, a somewhat disreputable approach, which I applaud. And I can give the clearest example of what I mean by legal pragmatism by sort of reversing the order of the title of the debate, and start with civil liberties. Then I'll say something very briefly about the law of war. I see civil liberties as simply the point of balance between the interest in public safety and the interest in personal liberty. And as the weights attached to these interests change because of circumstances or because of changes in public opinion or moral beliefs, the law changes, the civil liberties change. And it has been striking, and maybe Professor Cole regards this as a kind of cowardice or something, but it is striking how many distinguished liberal commentators recently, like Ronald Dworkin and Lawrence Tribe and Bruce Ackerman and Alan Dershowitz, and in the press, Nicholas Kristof of the New York Times, have said what I think is true, and I also think is sort of quintessentially pragmatic, that because the September 11th attacks and ensuing events have shown that public safety is more endangered in the United States than we had believed, it simply stands for reason that we have to re-examine the scope of our civil liberties, and we may have to curtail them. Now, one of the problems in re-examining this scope, I think a problem of particular concern for the people in this room, for us, for lawyers and judges and law professors, is that the legal profession tends only to be knowledgeable about the personal liberty side of the balance, because we're not experts in public safety, national security, crime control, and the like. Those understandings, knowledge belong to different fields. So how do you strike a balance if you only know how to weigh one of the interests that goes to make up the balance? So that's a serious problem. It's a problem that's obscured by the fact that when you read the Constitution, you read the constitutional cases, not all of them, but the bulk of them, they seem to be, it seems as if the only constitutional values are values of personal liberty, freedom of speech, freedom from unreasonable searches and seizures, right to a lawyer in a criminal trial, right to bear arms, and so on. Those seem to be rights against the government. But actually, the other side, the community interest, the public safety concern, the national security concern, these are just as much constitutional values. And the reason they don't give rise to actually judicially enforceable constitutional rights is a matter of practicality. You couldn't really craft a judicially enforceable right to national security, to criminal protection, and the like. So those constitutional values enter into the balance, and they're what limit the sort of relentless expansion in personal liberties. The alternative view, and it's dramatically expressed, and I'm sure many things that Professor Fletcher will say today, as he said in the past, is what I call, pejoratively, backward-looking, if more neutral terms, famous essay by John Dewey of Columbia University on law, written in the 20s, in which he contrasted what he called a logic of antecedents with a logic of consequences. By logic of antecedents, he meant a way of deciding cases in which you look backwards. You look at texts, you look at a history of judicial decision-making, and you try to fit those texts to your current problem. And that's legal formalism. And the logic of consequences is forward-looking, which you start by asking, what is the sensible solution to a new problem that confronts us? And certainly the world since September 11th, 2001 has presented us with new, novel problems. And how should we deal with those problems, looking at them freshly, without the burden of the past weighing too heavily on us? And if we find a sensible solution, then we look back and see, if we're judges or lawyers or law professors, whether this can be squared with the body of sort of conventional legal materials and the rule of law values that are reflected in a policy of adherence to past political settlements as embodied in authoritative texts. Let me jump ahead and just say a couple of things about. I'll now move into the question of the law of war by focusing on an issue which has been very important to Professor Fletcher and is emphasized in his book, and that is the different legal incidents that follow from classifying a struggle as war or as crime fighting. Now, as I say, these are classifications that carry with them very different legal consequences. Prisoners of war have a different set of rights from convicted criminals, for example, or even from pretrial detainees. So Professor Fletcher is very concerned about deciding whether Al-Qaeda and other cognate forms of international terrorism represent an enemy with which we are at war or a criminal gang that we pursue the way we pursue the mafia. That kind of classification approach to the question of how we deal with international terrorism, this to me is an example of the logic of antecedents, or the backward-looking focus of legal formalism. You have forms, the law of war, the law of crimes, and you try to fit a novel problem somehow to one of these. And the pragmatist says we indeed have a novel problem. There's no reason to think that the existing forms fit this problem. So we can invent a new form. We can borrow, if we want, from the existing forms. We can say, yes, we're at war with Al-Qaeda, and they are criminals, and we will have to devise methods of dealing with them that fit their unique case, rather than worrying about whether we're about trying to shoehorn them into one of the existing categories. And a similar problem arises now as we turn to the recent resolution of the Security Council. And Professor Fletcher has raised a question about this. He doesn't question the validity of the Security Council insisting on inspection of Iraq to see whether they have weapons of mass destruction. But he's concerned that to enforce the inspection regime or to forcibly disarm Saddam Hussein would be inconsistent with the United Nations Charter, which makes war lawful only in rather narrowly defined situation of self-defense. And self-defense in criminal law, and I suppose the United Nations Charter, is ordinarily understood in rather narrow terms. You have to be in reasonable and actual concern with an imminent, either an actual or a really imminent attack in order to be justified in responding violently. But on the other hand, in the age of nuclear weapons, maybe suitcase nuclear bombs and biological weapons and gas and so on, prudence or pragmatism may suggest moving the boundary and recognizing a much more expansive concept of self-defense. And again, the pragmatist is less likely to regard the particular language of the United Nations Charter or any other document as an absolute bar to dealing effectively with a situation that has real urgency and menace to it. So let me stop there. That will give you a rough idea of my approach and my perception of the basic differences that Professor Fletcher and I have.
Thanks, Judge Posner. We'll turn now to Professor Fletcher. And just as Judge Posner stated exactly in the 8 minutes, we're sure that Professor Fletcher will not be under or oversold.
Well, it's very gratifying to see this turnout. This is a tremendous tribute to Dick Posner, to Catherine McKinnon, to Laurie. It is great that you're here, and I'm going to ask you to be tolerant and patient because I think that I may get a bit passionate in the next few minutes. There's a lot to be said about how dangerous and insidious the philosophy of this wonderful, mild-mannered man can actually be. Now, nothing I have to say relates to Dick Posner as a person. In fact, it frequently is the case that the people whose philosophy I dislike the most are the people to whom I'm willing to lend money, without any doubt. So I don't question, Dick, whenever you're in need, I'm here. And, of course, judging on book sales, that may happen. I have no idea. I think that what the philosophy of pragmatism and law totally disregards is a very simple, essential idea in the rule of law, and that is the idea of commitment, a commitment based upon past events. And that means a commitment to the Constitution, a commitment to laws that are adopted, a commitment to the democratic system. These are fundamental, and they are all backwards looking because the things that lead to the commitment occur in the past. Now, just to give you an idea, I want to turn, just an idea of how dangerous Posner's views are, I want to turn to some arguments made in the chapter of his new book, which he kindly shared with me. This is a book about the pragmatic philosophy of law. It's not surprising that in this book, Posner defends Lincoln's suspension of habeas corpus. After all, why not? I mean, it certainly was practical and efficient to suspend habeas corpus in the course of the war. After all, you have to weigh the cost of benefits. Go ahead, do it. Now, I think that lots of consequences follow from that, but we won't focus so much on Lincoln's suspension of habeas corpus. I'm much more concerned about another chapter, and I hope that Dick has a chance to revise this before the text is printed. It reads like this, and I never thought I would see anyone make this argument. Because let me just say that I think that I have lots of trouble with Lincoln as a president, Lincoln's potential usurpation of power in the name of a good cause. But the one thing that redeemed Abraham Lincoln was that he stood for re-election in 1864. It never occurred to him, however contemptuous he was of the Constitution in many respects, however willing he was to violate the Constitution and never expressed a kind word for the Constitution. He always said that his political ideas came from the Declaration of Independence. Lincoln, so far as I know, never thought twice about standing for re-election in 1864. But listen to Judge Posner. Yet Lincoln would have been wrong to cancel the 1864 presidential election. Okay, thank you. As some have urged, by November 1864, the North was close to victory, and canceling the election would have created a more dangerous precedent than the wartime suspension of habeas corpus. Yes, but it's true. But what if the facts had been slightly different? What if, in fact, the North was not winning at that time? What if the argument in favor of the war would have required a suspension of the election or a postponement of the election? That happens in many countries around the world, and it happens precisely on the basis of the so-called pragmatic philosophy. It's a philosophy that disregards the commitment to stand by the constitutional order and to be willing to take risks that are incidental to a constitutional order. Actually, I'm reminded of a phrase by Benjamin Franklin. I'm not reading my book, I'm just reading a quote from Franklin. They that give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. And yet it's very clear that Posner's general philosophy favors giving up liberty for the sake of temporary safety. The reason that we cannot do that in our present situation is that we do not know when this crisis will end. Any temporary introduction of compromise measures, of military tribunals, of putting people in jail like Hamdi and Padilla without granting them a right to a hearing or a right to counsel, those kinds of compromises will become entrenched in the constitutional order. Actually, I'm reminded of an argument on behalf of my position by a really stirring, dissenting opinion by Judge Jackson in the Korematsu case. You're familiar with the Korematsu case. It's one of the cases of shame in the history of American constitutional law, but I think actually Dick Posner can see arguments in favor of it and would support it, I believe, under certain circumstances. So the argument is that in the case as it was decided was it legal to convict a person of Japanese descent because he disobeyed an order, this was during World War II, that required that person to show up at a point of assembly that would lead that person then to a confinement camp. This was a criminal prosecution for violating that order. Now, many people would say, okay, look, you have to balance liberty against necessity, and under those circumstances, who can second-guess the Army? But in fact, what I think is fantastic about Jackson's opinion, dissenting opinion in that case, which has lived on to become influential and indeed the compelling point of view, is to, if the case is decided like Korematsu, the principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Once you introduce that kind of a compromise into the legal culture, once you have a case like Hamdi and Padilla that stands up, once you have military tribunals, those cases, those precedents will be a loaded weapon that others can use to compromise even further in the name of protecting security against liberty. Now, my real criticism, my fundamental criticism against Posner is that for someone who believes in the economic system, in fact, he is a statist thinker. He is a statist thinker who, in economic terms, would believe in central planning. Actually, I'm inspired in my opposition to Posner by Friedrich Hayek, who actually argued that you should never trust the state in the making of definitive judgments. You can't trust the state. The state is not competent to develop central planning, and it's not competent to make the kinds of decisions that Posner would like the state to make, namely to balance liberty against security. And in fact, Jackson made this wonderful comment. So the court, having no real evidence before it, has no choice but to accept General DeWitt, he was the military commander for that region, but to accept the military's own unsworn, self-serving statement, untested by any cross-examination, that what he did was reasonable. But Posner's view is, sure, you have to defer to judgments made in the Defense Department, judgments made in the Justice Department about the relative worth of security and liberty. I think those are the ideas that are precisely in opposition to the rule of law. And unfortunately, what they represent is a distortion of the very tradition of liberty in the marketplace that Posner in other respects tends to support. This is turning the idea of the market, of skepticism for central authority, on its head. Thank you.
Thanks. Now we have about 3 or 4 minutes of rebuttal, I guess
Okay.
Time? Yeah, that was perfect. That was exactly right.
Let me just correct a mistake that Professor Fletcher made in his carried away by him. Justice Jackson in the Korematsu case did not question the legality of the military exclusion order. His dissent was from a judgment that upheld the criminal conviction of Korematsu for violating the order. So he thought in wartime that you had to give the military its head, but he was unwilling to allow that military order to be backed up by criminal punishment. Professor Fletcher's reference to Lincoln really does draw the issue sharply. I think Lincoln did violate the Constitution when he suspended habeas corpus. The reason is that the Constitution makes it about as clear as you get in a legal document, subject always to interpretation, that only Congress can suspend habeas corpus. But I think he was right to do so. I think the law of necessity, not a positive law, but a kind of law of survival or biology or something, does trump a positive law. The situation for the Union in the early months of the Civil War was extremely parlous, and there was serious danger that Maryland would secede, and in that event, Washington would be surrounded by rebel territory. There were plots to assassinate Lincoln, and the Union Army hadn't formed yet. It was an extremely dangerous situation. It was not only important for habeas corpus to be suspended, so that the case that went up to the Supreme Court, where Chief Justice Taney, that distinguished liberal of Dred Scott fame, issued a writ of habeas corpus, which the administration simply disregarded. That was the Merryman case, and Merryman was a Marylander and was believed to be a Confederate a sympathizer or agent. So it was important to round these people up, number one. Number two, it is very important at the outset of a war to show yourself resolute and not weak, because if you show yourself weak, then civilian morale is likely to collapse behind you. And I think it was more important to preserve the Union than it was to honor the Constitution in that particular. With regard to 1864, with the election, yes, I can imagine situations in which it would be the right course of conduct to cancel an election. I mean, suppose a few days before the election, some international terrorist group managed to kill all the candidates. Well, wouldn't you have to cancel the election? All you need is imagination to think of many cases in which common sense, and ordinary survival instincts require compromising one's ordinary commitment, if you want to use Professor Fletcher's word, to standard norms of legality. I think commitment is relevant. I think it is an important part of what we understand by the rule of law. But a suicidal commitment, it was Justice Jackson who said, and it's been repeated many times, is that the Bill of Rights should not be interpreted so as to make it a suicide pact. And we can think of many other examples. I mean, suppose that judges of the Weimar Republic in 1932 or 1933 had prevented Hitler from becoming chancellor. Wouldn't we all think that that was a good result, even if it violated the Weimar Constitution? So the question I have for Professor Fletcher is, is he really prepared to commit national suicide in order to maintain a commitment to texts that were written by people who couldn't possibly have foreseen the circumstances in which their text would be placed under this tremendous strain? I don't think you do a favor to the framers of the Constitution or the judges and justices of yesteryear if, taking their words literally, you use them to destroy the values that were fundamental to them as they are to us.
Professor Fletcher.
Let me bring the theme home to the problem of going to war, because as in the same way that we all have commitments to the Constitution and to the basic laws of the United States, the American government has a commitment to the United Nations Charter, and it should have a strong commitment to the resolution that was just passed by the Security Council of 1441. Now, so far, the behavior of the Bush administration has not reflected a sense of commitment to the United Nations Charter. That is, the general attitude is we can interpret the principle of self-defense under Article 51 any way we want to. We can engage in preventive war if we make a judgment that this is a desirable move to make. And even though the United States voted for this resolution on November 8th, it's not clear that the United States will abide by its terms. In fact, I see an enormous conflict developing in the next couple of weeks between Russia, France, and China on the one hand, and the United States on the other, because Russia, France, and China made an explicit declaration that they heard an explanation of the American and English vote in favor of returning to the Security Council, which has remained seized of the problem of disarming Saddam Hussein. Now, the United States has not officially recognized this view, and indeed there was a very unfortunate statement by Kofi Annan yesterday in the newspaper that he recognized the capacity of the United States to go it alone. Now, this strikes me, I think Kofi Annan must have been under extraordinary pressure to make this kind of a statement, which was in fact a betrayal of the fundamental principles of the United Nations. So specifically with regard to the war, we're going to see a fundamental problem. Do we recognize our commitments to uphold a multilateral system of international peace and order, or are we going to defend a principle of unilateralism? Now, I actually think that Posner's philosophy leads in favor both of exhilaration or an undue reverence for the judgment of the present generation as opposed to the past, and it also leads to an excessive emphasis on unilateral judgment as opposed to multilateral judgment. So the same philosophy of pragmatism, so-called pragmatism, other people would call it opportunism, the same philosophy of opportunism/pragmatism leads to very unfortunate consequences in both arenas.
Well, I don't really see how...
I guess we'll give him a minute each. Yeah, we'll give you a minute each.
Well, I don't really... I don't suppose this generation is particularly brighter than the previous one, but I don't see how the framers of the Constitution can be laying down the law for us with regard to how to deal with international terrorism or nuclear bombs. They didn't know anything about that. How can we? But I want to say something about the United Nations, because after all, one difference between Professor Fletcher and myself, I do believe there's a fundamental difference kind of between formalism and pragmatism. So when I think about the United Nations realistically, this is what I think about. Imagine the American government constituted as follows: 50 states, of which 2/3 are dictatorships. A lower house of Congress, House of Representatives, which all 50 states are represented, but each has just one vote, despite differences in population. A Senate consisting of 15 of the states. 5, for historical reasons, have a permanent membership in the Senate, and each of them has a veto. It includes Massachusetts, because it was one of the early states, and Virginia, because so important in 1787, includes Vermont and Arizona, and then 10 more states which are chosen more or less in rotation. And they serve for a couple of years, and then they're rotated out. There's a very weak executive, someone called a Secretary General, has really no powers. He's elected by this legislature. And then there's no judiciary. So if we had a government like this, we would laugh. We would think it was the most absurd governance structure you could possibly imagine. Well, that's the United Nations. Now, the United Nations has its uses, has its utility, and I think it's demonstrated with this resolution of the Security Council about Iraq. But for us to genuflect at the United Nations and regard its decisions and its undertakings and so on with the same respect that we accord a modern, democratic political system with branches and separation of powers and the panoply of modern government, I think is just extremely unrealistic. And we should think realistically about law, whether it's our law or the law of the United Nations Charter, and not just treat these as interchangeable sacred writ.
George, you want a brief riposte, and then we'll turn
I actually want to come back to my idea then. I love this compliment that I'm a legal theologian and that I believe in sacred writ and all of these things. It's so much better than being a legal atheist. And that seems to me basically the position that Posner's in. It's hard to know whether there's anything that that Posner believes in other than the judgments of this nation, this generation, the judgments of the moment, designed to supposedly to further welfare in the future. It does take. I want to respond just to this idea that we have to be afraid of the idea the Constitution is a suicide pact. I think that's a very unfortunate expression. In fact, it has been used primarily in cases that uphold civil liberties. That was the most famous usage in Trump versus Dulles by Justice Goldberg. It's cited frequently now in favor of all the arguments in favor of compromise, opportunism, giving away our liberties. I think it's very unfortunate. My own view, in contrast to that, is that the Constitution, and I would say the same about the UN Charter, these are invitations to courage.
Okay, I think we're ready to turn to our interlocutor, and we'll give her as much time as she needs.
I'd just like to start with a very brief observation about what's taken place so far, and then I'm going to ask one question and save the rest of my time for asking further questions after they answer that one. It's interesting because when you read the work of both of these men and also listen to them speak, we have Judge Posner coming on as the man of reason, and George Fletcher coming on as the man of passion. And it's interesting to see there be a more hawkish side coming out of the man of reason and the more dovish side coming out of the man of passion. And then we're told that the man of reason is the more pragmatic, which wouldn't just be what the Enlightenment in its stricter form would lead you to think. And then we're told the man of passion coming down with the formalistic, which is more generally thought to be principled view, more often seen as cold. And I'm just trying to make sense of the twists and turns of all of this. And I think that it might help if both of you addressed squarely one question. That is, in a certain sense, you're talking about, you tend to be talking about two sort of whole different bodies of material rather than focus on one thing. So I'd like you both to answer the question, are we in a war?
Okay. Yeah, I would say so, yeah. From a practical standpoint, the difference between war and crime is just the degree of danger. And the danger that international terrorism poses is actually greater than that has been posed by a number of our enemies, that is, our official wartime enemies, like North Korea or in the Korean War, 1950-53, and Vietnam. The fact that it is not a state that we're fighting, although it was able to subvert a state, was able to take over Afghanistan, and may be able to do that in the future. But it is dangerous as a wartime enemy and should be treated accordingly. Now, actually, the Confederacy in 1861 to 1865 was not a recognized state. It was a rebel. It was, a collection of rebel states. Rebellion and war are often paired, as they are in the provision of the Constitution that authorizes suspension of habeas corpus by Congress, as during war or rebellion. So when violent activity directed against the United States reaches a level of danger that it did in the Civil War, or that it does today, I think, then we have to respond with the same resoluteness and energy and sometimes ruthlessness and violence that we would if we were facing a formal a wartime enemy.
My answer is actually here rather instrumental and pragmatic. I think the concept of war is a more useful one to adopt rather than the prosecution of crime or the punishment of crime. I'm afraid that the government slides back and forth depending upon which one will permit the greater use of violence. The notion of punishing crime, of course, permits you to punish crime even if there's no future danger. You could execute Eichmann, you can convict Milosevic even if they're not dangerous in the future. In a case of war, you cannot do that. That is, if there is no further danger emanating from the enemy, then you have to recognize that hostilities are over and no further force can be used. My biggest problem in the current situation is that we don't know whether that's the case or not, and we will not know when we have won. If we could say it was a war, then of course all the detainees in Guantanamo would be entitled to prisoner of war status. This would be desirable. The government doesn't recognize that. But I think actually, even though the term war sounds much more dangerous and nasty, it in fact has a more humane side.
So the answers are yes and maybe not.
Maybe. Well, yes. Yes.
Right?
But my answer is very different because my answer doesn't commit me in my mind to treating these people as prisoners of war. If that's not the sensible way to treat them, because we need information in a way that we wouldn't if we were just rounding up ordinary soldiers.
See, this is where
in Nuremberg we merged war and crime. We punished our enemies. It was victor's justice at Nuremberg, punishing our enemies with the forms of criminal justice, but not the reality of criminal justice. It was not a proceeding that comported with due process of law. I think it was a sensible, realistic, prudent way to proceed, even though it did rather break the mold of conventional rule of law notions. I don't know what Professor Fletcher thinks of the propriety of the way the victors proceeded at Nuremberg.
On the whole, I think I would defend Nuremberg, but the interesting problem is if we are at war, then the ordinary soldier in the enemy army does nothing wrong by fighting in that war. And you cannot use a notion of crime or a notion of war crimes or crimes against humanity against someone like Hamdi, who, so far as I know, was simply a fighter for the Taliban. Now, it doesn't make any sense. You cannot say that everybody who fights for the enemy is now guilty of a crime, and we're entitled to confine that person in order to gain information. See, the process began after September 11th by people not knowing, was it war or was it crime? And they ended up in Guantanamo Bay saying, it's neither. We're not going to treat them as criminal suspects. We're entitled to constitutional protection, and we're not going to treat them as prisoners of war either. I think that is a total bankruptcy.
Precisely. And for me, the question is, are there good reasons to equivocate?
Yes, it's in our interests, but that's not a reason that should prevail in legal discourse. That it's good for us.
Let's explore what those interests are, how important they are. Doesn't the importance of the interests matter to you?
I have actually a question that maybe if you addressed, you could continue this same dialogue, and that might be who should decide if Resolution 1441 is violated, and should the United States unilaterally enforce Security Council resolutions?
Yes. I would be strongly opposed to the United States claiming that it's entitled to enforce the resolution, although it does seem that Ambassador Negroponte made a statement to that effect, that at the time of the vote, and he made a press release saying the United States would regard itself as implicitly authorized to enforce the resolution. That is, what the United States will decide is that Saddam Hussein is in violation and will then proceed to conduct airstrikes. If that happens, that would be a total corruption of the principles of the United Nations. That is, we went to the United Nations in good faith, we participated in the debate, we voted for the resolution, and now we're going to make an entirely extra legal claim that we're entitled to enforce it.
well, I actually have his language here. What he said was, if the Security Council failed to act decisively in the event of further Iraqi violation, the resolution did not constrain any member state. So, but that actually strikes me as an international lawyer as maybe something of a technicality about this. I think the bigger questions that we're debating about, why should the UN Charter be sacrosanct? Why should the Constitution be sacrosanct?
Right, it's the values underneath it that I was getting at, that Dick said we should be, more directly engaging. And I was...
Well, again, I think it's an issue of commitment and good faith as opposed to thinking all the time about the world from our own point of view and thinking that because it serves our interest and our balancing of the interest that we're entitled to act unilaterally. There must be some situations, Dick, in which you're willing to say, no, we can't do it, even though it looks reasonable and desirable from our point of view. We can't do it because we are constrained by prior commitments to the Constitution or the UN Charter.
I prefer to say there are situations in which, when you balance the gains from some course of action against the costs, you may decide that although there are gains, maybe even substantial gains, the costs are more significant. And the costs could include the costs of flouting some document that you've just signed or that you've regarded as authoritative. I think rule of law values that argue for adherence to commitments, I think they're very important. But what makes a wartime situation interesting is that that's one of the occasions on which you have such a heavy weight on the other side that even the rule of law values give way, unless you want to take really, Professor Fletcher talks about courage and about taking risks. Well, just how large a risk is he prepared to take? That's the question for me. Is he willing to take any risk, or does he draw a line at some point where, yes, we would have to unilaterally enforce a Security Council resolution or ignore the United Nations entirely or ignore the Constitution because something like national existence or survival of a huge number of people was at stake? I'd be interested in whether he thinks there's any escape hatch from commitment to prior generations of limited foresight.
I think there are situations in which military leaders and political leaders have to take the responsibility for engaging in what is the equivalent of civil disobedience. That is, there comes a time where you say, we recognize our commitments, but the immediate situation requires that we act. Now, I don't think that Lincoln was justified in suspending him.
Why do you say that? Are you a historian of the Civil War that you're able to say that Lincoln could have ignored the Merriman and the other Confederate agents without significantly endangering the Union's position?
Well, it's very difficult. You see, you're not certain. We know about probably I'm sure you know more about this than I do, but I think the fact is that no one can make that assessment retrospectively as to what the quantity of the risk is, and no one can make it at the time. There's no way of knowing. Lincoln didn't have such great sources of information. He spent half the day in the telegraph office
waiting for... So what would you have done if you were Lincoln?
I'd like to add a couple more examples to this vocabulary.
Let's let Professor McKinnon get in at least a few more questions.
Just to get us a little beyond 1864. And this, I think, is perhaps more to Judge Posner, but I'm sure Professor Fletcher would have views on it as well. And that is, it's one thing, we can say that rights are more, as Judge Posner did in the Constitution, and security, according to him, isn't very. And I'm a little struck by the sort of Grand Inquisitor-like quality a bit of what you're saying. In other words, everybody's praying to this guy and he doesn't believe in God. I mean, you're a judge and you're telling us that these rules really have their limits. And in other words, here are a few more examples for us just to think about how it is the pragmatism you're presenting does or doesn't just amount to a tool of the convenience of power at the moment. For example, the Steel seizure case by Truman during the Korean War, which was invalidated by the Supreme Court. It was undertaken as a security move, invalidated by the Supreme Court. National security wiretaps without prior judicial approval were undertaken during the Vietnam War, were rejected. Now, you may think these were wrong, and these are just examples of the way security is not properly entrenched in the Constitution and rights are, but I'd like to know that. And similarly, the Pentagon Papers case, during the height of Vietnam, was a refusal of the government request to enjoin publication. Again, you can just say these are rights, they're entrenched, and security isn't. Or maybe you think pragmatically something was done that was correct in that instance, and was it because we weren't at war during those times, or what?
Oh, I don't think it's significant that we weren't technically at war with either North Korea or North Vietnam. That business of declaration of war. That's a formalism that.
Well, but state of war is also a reality, and I wasn't assuming just by virtue of declaration.
Right. I didn't know whether you were using its technical sense. Someone has to make the judgments. The judge, if a case is properly presented, the judges have to make a judgment, and I think they should defer to a significant degree to the president, who's going to be blamed, if you lose the war. But there are limits, and I think the Steele seizure and the Pentagon Papers cases are marginal. I don't know about these national security wiretaps. We're obviously back in the wiretapping business. We do a lot of wiretapping. We have judicial controls over it, but we do wiretapping in criminal investigations. And indeed, there's some question whether the special, electronic surveillance court in Washington was too restrictive in its policy toward national security wiretaps before September 11th. But I'm not a Grand Inquisitor type. The essence of the Grand Inquisitor's approach is two levels of sophistication. You have people at the top who are very cynical and see through the forms, and then you have the ordinary people
who believe in them,
who believe these things.
Including limits of rule of law.
That is not my view, because I think judges should be candid about what they're doing. I don't think they should pretend that. Professor Fletcher's approach actually creates arms the judges with a very deceptive rhetoric, which I think is undemocratic and actually bad. I think it deceives the judges as well as the people. And that is the pretense that when a judge makes a decision, all he's doing is applying some past decision. The decision was already made. It's buck passing, right? That is typical judicial rhetoric. If you think this is a stupid decision, a suicidal decision, don't blame us, blame Madison, for example. I hope I don't do that in my own judicial opinions. I do not believe that that's a proper way for judges to express themselves. It's not the way that Holmes expressed himself, for example. I do think American judges are pragmatists, but they do they do very often, typically use a formalist rhetoric. I particularly worry about deceiving yourself, because if you get to believe that what you're doing is just applying decisions made 150 years ago, you can be very lighthearted, right? Send a person to the electric chair or something, or lethal injection. It wasn't I who did it. It's the people who drafted the Eighth Amendment and left out, death as a form of cruel and unusual punishment. So that particular approach, that two-tier kind of approach, I strongly reject that.
I think we're getting to the point where we are going to want it open for the discussion from the floor. Professor McKinnon, did you have a last set of questions or a few points to put to our presenters here?
I think just one final point about the structure of this, and in particular, I guess, and I don't want to center my comments particularly on those by Judge Posner, but I think I'm about to. And that is...
That's okay. I have plenty of things for Professor Fletcher, but...
Thank you. Good. Somehow it's the idea that, it's as if there's no form in your pragmatism. That is, that is worrying to me. And, given that a lot of antinomies such as rationality and irrationality, not to mention war and peace, are often overdrawn, it just, the notion that the reason, for example, we don't have a constitutional right to security is because it's too hard to craft. Well, we have a right to equal protection of the laws, one that has been violated, including in wartime, and one on which the U.S. has reserved with regard to the ICCPR, even, including, and that's rather recent. But it is then interpreted in a negative way, not because it can't be affirmatively crafted, but because the notion that because negative rights have been the formal model. It certainly can be crafted. It has been more in Canada and in fact, in affirmative terms in the Constitution of South Africa. It's not that we can't do that. And I guess when I think of it that way, it makes me wonder about phrases like common sense and survival instincts require a compromise of ordinary standards of legality, and how I'd like to see that come up in circumstances like battered women claiming self-defense and killing their husbands because of the degree of danger that they find themselves in on a routine basis. Law was not written with them in mind. It was not written by people like them, just as the people who created I think the people who wrote the UN Charter had more sense of the realities of what terrorism might eventually look like than the people who've created the existing law of self-defense in U.S. criminal law had of the situation that battered women face on a daily basis. And in other words, what I'm trying to get at here is that there may be forms, including the negative state positive rights form, that one engages in a certain amount of selectivity in deciding about which one is going to be pragmatic on a day-to-day basis, and one just doesn't simply say, well, I guess men wrote that, and they weren't thinking about women, so just to be pragmatic, let's ignore federalism and uphold the Violence Against Women Act? In other words, federalism then, is that just a product of pragmatism, or is it a formal structure that needs to be questioned? In other words, it's the tension, the content of these two things that seems to me to be highly questionable, and the same sorts of questions get raised on an international level as I've just been, exploring them on the more national level that your discussion has centered on.
Well, I think you're really making my point when you talk about the battered women, because we have a criminal law of self-defense based on certain understandings. And now suppose a body of knowledge is developed and people decide that in case of battered women, the self-defense, the concept of self-defense should be expanded. So should we say, well, but in 1787 they didn't know about battered women, and so they had a very narrow conception of self-defense, and we're stuck with that? Or can we use our modern knowledge, even though we're this kind of meager present generation, with cheesy values and dress badly and so on. So, and with regard to the Violence Against Women Act that the Supreme Court held unconstitutional, well, the Supreme Court in recent years has been embarked on a program of imaginative, recreation of some notion of what the United States was supposed to be in 1787, more of a federal system, less federal power. That's political. It's a political court making political judgments. You can agree or disagree. You can give reasons. You can present evidence. And that is the level on which it should be discussed, not in terms of whether somehow they have captured some atmosphere of the 18th century and have now discovered belatedly that we got away from that the last 50 years. Now we have to restore it.
Okay.
Until we're realistic about the legal process, how do we make progress?
The present generation is going to have about 20 minutes of discussion. We will move on. So, yes? Okay. So we'll take your questions, and I'll try to scan the room and see who's around. Okay. Way in the back.
I have a question for Professor Fletcher. I'm wondering how your formalist approach admits a difference between violating the Constitution and violating the UN Charter, because it would seem to bind us to both, whereas I think there needs to be some way to distinguish the costs in violating one from the costs in violating the other.
Well, actually, I agree with you. I think one of the real puzzles in legal theory is how to relate international law to constitutional law, because actually, Professor Damreich gave me a difficult question on this at one point about how we can justify allowing our citizens to be tried in procedures that in fact violate the Sixth Amendment. And anyone who takes the Constitution seriously would have to have serious doubts about the International Criminal Court. On the other hand, there is this long tradition of regarding international law as superior and restraining our activities. One thing I would assert very clearly, though, is that the democratic process is no substitute and no license for violating our international obligations. Just because Congress authorizes the president to go to war, that does not resolve the question whether we're entitled to do so under the United Nations Charter. That's a whole different set of questions regulated by treaty. Yes.
Okay. Yes.
Yes, I have a question for Judge Posner, which turns on the issue of trusting the state. He likened or compared, he cast the state in the role of expert with respect to national security, but isn't there a distinction between expertise and the question of responsibility or authority? The state certainly has responsibility and authority for national security, but in casting this in terms of expertise, he perhaps thinks in terms of the legal system's relationship to medical, scientific, statistical, forensic, other experts whose conflicting testimony, I gather, I'm not a lawyer, the legal system will consider. But in a democracy, there are many alternative sources of expertise about national security other than the state. There are think tanks. There are retired officials who serve with distinction, like Brett Scowcroft. There are perhaps even some tenured professors who have something to say about the matter. Doesn't this atrophy citizenship and shrivel citizenship in times of war or emergency by ascribing to the state expertise as distinct from authority and responsibility in questions of national security?
Yeah, I was just meaning to compare the judges, lawyers, and the rest of the legal profession on the one hand with the government on the other when it comes to weighing issues of public safety. And the judges and the lawyers and law professors, I think, are really very poorly equipped to talk about public safety. It just isn't their business. They don't know anything about the very complicated geopolitical relations and military risks and opportunities. And this also has a technological dimension, obviously, these weapons of mass destruction. How dangerous they are, how easy to develop, how easy to conceal. There is enormous expertise involved in these issues. You're certainly right. The expertise isn't all in the government by any means, but some people, after all, regard the recent election as a referendum on our dealings with international terrorism, because these experts, they publish, they're picked up by politicians and paraded, and their views expressed and amplified and so on. So there is public debate. What I am concerned with is the judges making judgments in areas which they're not that confident. I'm also worried, just to pick up on what the previous question was, I think there's a real tension between two liberal values. One is democracy, the other is internationalization, because the international bodies to which we cede sovereignty when we, sign treaties and join subscribe to international courts, these are not actually democratically constituted bodies. So we're progressively surrendering sovereignty to international groups that don't have democratic values, democratic structure, democratic procedures.
But in fact, I think your position violates some very fundamental legal values. And I go back to the statement by Justice Jackson that criticizing reliance upon the military commander's statement of expertise, saying, okay, the statement is unsworn. We do make a difference between sworn statements in court and unsworn statements. It's untested by cross-examination. Surely cross-examination is a critical question, even for hearing expert witnesses in court. Just relying upon a statement from the Defense Department about the likelihood of a major attack in the next few weeks or something, this deference to this kind of, and this is the third point that Jackson emphasized, self-serving statements. These have political value from the point of view of maintaining the government's power and authority. And it seems to me naive not to recognize the corruption that is implicit in deferring, quote, to the expertise of government. This is the last thing that we would want to do.
Yeah, that's really a bad example because that military exclusion order was issued in March of 1942, which was 4 months after Pearl Harbor. And not only was there enormous uncertainty, but the military was concealing a good deal of bad news from the American public in order to maintain morale. It was not possible to have a wide open democratic debate right at the outset of the war. And regarding Korematsu, by the way, Professor Fletcher ought really to applaud the decision in Korematsu because it is formalistically impeccable. And the reason for it is, remember, the complaint about Korematsu, the complaint about the order, was that it was racially discriminatory. But in 1942, there was no principle that the federal government was forbidden to engage in racial discrimination. The reason for that, the Equal Protection Clause of the 14th Amendment says no state shall deny the equal protection of the laws. There's no reference in the Constitution to the federal government being forbidden to deny the equal protection of the laws. In 1954, the Supreme Court in Bowling versus Sharp held that the Due Process Clause of the Fifth Amendment included an equal protection component. I mean, implicitly included it. Now, that decision has been ridiculed by formalists as absolutely contrary to the text of the Constitution. It certainly was unanticipated in 1942. I have defended it as a pragmatic decision on very simple grounds. The Supreme Court had just held that racial segregation in the public schools of the South was unconstitutional. If it had taken seriously the fact that the Equal Protection Clause does not reach the federal government, it would have been required to permit the continued segregation of the public schools in the District of Columbia. That would have been such a ridiculous result. Try explaining that to a layperson. Supreme Court has just held that racial segregation in a public school in the United States is unconstitutional, except in the District of Columbia. So the Supreme Court justices happen to have school-age children going to public school. They would go to segregated schools.
All this is beside the point when it comes
to
Korematsu.
It's not beside the point at all, because it shows that some of the most treasured principles of civil libertarians and civil rights supporters are the result of decisions that a consistent formalist would regard as unprincipled, such as Bowling versus Sharp.
That's not really what, insofar as we can take the opinions.
I think maybe we're straying a little far from the war topics. Right. So let's, we've got some patient questioners out here, and I'm going to call on this one right.
That's correct. I did say that. I think you're painting with a broad brush. Yeah, I'm sure. I suppose common sense to a terror. Yeah, they I suppose have their own notions of common sense.
But say, why couldn't
But
Iraq use it?
I'll give you an example, actually, from Professor Fletcher's book of this, because he discusses the following case. He suppose during World War II, after Poland has been taken over by Nazi Germany, and you know, of course, the Germans killed millions of Poles, both Jewish and non-Jewish. After Poland is surrendered, taken over, a Polish farmer, I think it is, attacks a German soldier. And Professor Fletcher says, well, he has, because there's no longer a Polish army and he's not a member of it, what he has done is illegal. He has violated the law by killing this German soldier, and there is no, principle of international law or anything like that to shelter him, so he is rightly punished for, this is the illegal combatant. Well, I would prefer a more situation-specific analysis of these situations. And it's on that basis that I would defend the Nuremberg Tribunal, even though you could say, logic of your argument was this was kind of terrorists' justice, because after all, the Nuremberg Tribunal was not impartial, and it condemned the German leaders for actions they had taken that were legal under their law, under German law. And in addition, the tribunal condemned these people and executed a number of them for violating nebulous norms of international law that had not been clearly formulated when these people acted.
Well, thanks for bringing up that case, because I think it actually illustrates a weakness in your approach, which centers always on what's good for us, how do we make the judgment, how do we proceed with our pragmatic sensibility. That example from the law of war is based upon the principle of reciprocity. And the basic idea behind reciprocity is that if civilians are going to claim special status under the law of war, then they also have obligations. And they have obligations under occupying armies. And one of them is to recognize that they simply cannot act as though they were still engaged in hostilities. If the civilians want to act as though they're still engaged in hostilities, then they're subject to reciprocal reprisals that can't be avoided. That follows from the principle of reciprocity underlying the law of war. Now, reciprocity is a fundamental value in what you call the logic of antecedents. This is not something that is going to improve the welfare of society, but it's a recognition that we live in an interdependent world and that we cannot claim a right of self-defense against Iraq that Iraq does not have against us. You have to recognize it for both sides.
I'm going to call on Professor McKinnon, then we'll get a few more questions. Yes.
I was actually just going to ask this question about Iraq specifically. It seems to me that that when it comes to degree of danger, that Iraq might well right now say that their survival instincts require compromise of ordinary standards of legality, and they ought to be able to attack us in preemptive self-defense. I mean, we have a president and who said, "We're coming after you," and in other words, how might the two of you address that question other than that we're us and they're them?
I agree with you completely. I think that Iraq has a much better case for the use of force than we do at this point.
Well, now, wait a second.
Okay. Now, wait a second, please.
Wait a second. When people start to talk that way, they are committed, I think, a very deep, actually, I think it's crazy anyway, but I think it's a deep philosophical fallacy. It's actually, maybe it's a fallacy of Enlightenment thinking. That is, the notion is always a common ground. We can always forge a common ground with Al-Qaeda, with Saddam Hussein, with anyone. And we can sit down with him and we can say, we have principles of reciprocity. We have to treat you in a certain way so that you'll treat us in a certain way. If we don't recognize your right of self-defense, we have no right of self-defense. I disagree with that. I think we divide the world into the people that we can talk to and the people with whom we have to fight. And it's really just as simple as that. The people who thought otherwise, thought Hitler was reasonable, Hitler could be talked to, they were profoundly wrong. Think of when Hitler in 1936 reoccupied the Rhineland. Rhineland, the west bank of the Rhine River, was part of Germany. This was not a warlike occupation. In retrospect, most people believe that at this point, when Hitler was still weak, the French should have invaded Germany and strangled the serpent in its cradle. And I agree with that. So I think there's such a thing as being too principled, too even-handed, too abstract. After all, when Professor McKinnon starts talking about, well, Iraq, here's the United States. Here's one country, here's another country. There are no relevant differences between them because they're both countries. So they're both countries. They both have a right of self-defense. That's abstraction. And I prefer to be very concrete, especially when we're talking about our international relations. And distinguishing among countries, and if we identify a country as a very serious danger to us, then we deal with that country as an enemy. Not as a citizen protected by the Constitution, but as an enemy. And do you disagree with that?
Yeah, I do disagree with it. I think that if the United States had some principles in its conduct of foreign policy, we might not have this severe problem in the Middle East today.
That is a completely uninformed political judgment, because Professor Fletcher, with all his learning, is not an expert on the mentality and the politics and the ideology and the social environment and the religion and the language and culture of the Middle East.
I understand that, but we did have a prior policy of dividing the world between rogue states and good states. They were called communist states. And at the time, we were willing to support any state that said it was anti-communist. That was enough to get American support. And that's what led us into a number of mistakes, indeed including supporting
Professor Fletcher, do you regret the fact that the Cold War ended with the collapse of the Soviet Union and the other communist countries?
Well, let's have that.
That's not, because after all, we don't know exactly why the Soviet Union collapsed and why the Cold War ended. But the fact was the United States did struggle with the Soviet Union and its satellites over a period of almost 50 years, and we did a lot of nasty things and supported unpleasant governments, not in the same scale as our enemy was doing, but we did do a lot of unpleasant things. And it seems to me, to make a complete judgment, you would have to be able to relate these actions of ours, these belligerent actions of ours, to the termination of the Cold War. Now, if you concluded that if Professor Fletcher dares to conclude that if we'd been entirely passive, the Soviet Union would still have collapsed as and when it did, peacefully and so on, then fine. But if you can't make that judgment, then we should be open-minded about the degree to which our aggressive, our resolute stance during the Cold War brought large benefits, not only to the United States.
Okay, ladies and gentlemen, I've been informed first that we can go to 5:40. Second, that if you're going to ask a question, please speak into the microphone, and if the microphone is not where you are, please go to a microphone. And first person is in the back row back there, and then right here.
Hi, Judge Posner. The way I understand your pragmatic view is that we ought to adhere to the Constitution when it's expedient, but when another outcome is desirable, then there's no need to. As a law student, I find it shocking, if not somewhat refreshing, to actually hear someone say that.
Well, I didn't say that. And my question to you is, what do you mean by the Constitution?
I guess I mean I guess I mean the document and the decisions that were.
Here's the document. And what you will find when you read this document is something which bears only a modest relation to the body of constitutional principles. And those are the products of judges. And the judges over a period of, it's 200 years now, they have frequently changed their minds. And so this is an unstable and ever-changing body. And now perhaps Professor Fletcher wants to freeze it, as if maybe 1969 when Earl Warren retired. So,
I think I'm not sure that our questioner quite got to the end of his question, but
there's still a question coming.
There's still a question. Okay. This was anticipatory self-defense on Judge Posner's part. He just let you finish the question.
So presumably, the way that one decides whether something is desirable is by weighing the risks. Okay, assuming that the people who actually know something are not judges, then my question is this: what is the point of having an appellate judiciary?
Well,
we can't.
I better be able to answer that, right? Otherwise, I jeopardize my employment. It's two functions. One, there's an error correction function, and there's also an attempt to make law coherent. Now, when I say that, then you'll come back and say, well, I'm admitting there's such a thing as error, there's such a thing as law, and am I undermining my position? But what I believe, and my views on law are bound to be somewhat misunderstood, because in this setting, because we're talking about the real testing cases of national emergency and other urgent constitutional questions. And it's when we're dealing with the Constitution, and particularly when we're dealing with the Constitution in a setting of national emergency, we're putting the concept of law under its greatest strain. But there's a spectrum. The other side of the other end of the spectrum would be an ordinary commercial contract. And I would say that in general, in interpreting contracts, you want to be pretty literalist, because people who go to the bother of writing out their contract do so in major part in order to have protection against having a judge or a jury impose upon them obligations that they were unwilling to undertake.
That's terrific. And the Charter
now,
of the United Nations is a contract.
Even in the contract case, we have a principle that if a literal interpretation will lead to absurd results, we jettison the literal interpretation. That makes perfectly good sense. Now, what Professor Fletcher just said is that UN Charter is a contract and the Constitution is a contract. I don't agree with that. The differences are so profound. The stakes, the reliance that's placed on the literal terms, and so on, that they just can't be discussed in the same terms.
There is actually a very important legal issue about resolutions of the Security Council and whether they can be enforced on a finding of material breach, but that's going to get us a little far from the contract law doctrine. Yes, you're the next.
Thank you. Can I ask two questions real quick?
If they're quick.
Okay. Judge Posner, in regards to the tension that you pointed out between democracy and internalization, now the violation that the United States government is holding the Iraqi government accountable for, trying to hold, is a violation of an international treaty. Various Security Council resolutions. Right. So then how consistent is your argument to say that we can hold them accountable for violation of this particular law, but we will unilaterally claim that we will not do whatever that law requires? And secondly, I don't understand what is wrong for you, as far as you're concerned, as a judge, to require the federal government to bring Padilla and Hamdi to American citizens before you, so that you can review what the government is doing, and so that you can exercise your power under the Constitution and obligation to give these people their constitutional rights. In other words, why, as a judge, are you so ready to surrender your authority without questioning to the executive government? Thank you.
Well, regarding your first question, yes, no, I agree with you. To say that, well, put it in contract terms, to say that someone is violating his contract and therefore should be punished in some fashion, and then to say, and we're going to punish him anyway, even if the court determines that he didn't violate the contract at all. Yeah, that's inconsistent. It's obvious that. I take it's obvious. I don't want to cause a diplomatic innocent or anything, but I take it that the United States is not an enthusiastic participant in these United Nations, inspections and the resolution and so on. The United States apparently the administration would have preferred to go it alone or with just United Kingdom, but that because of international public opinion, European opinion, and so on, felt it politic to resort to the United Nations. But our relations to the United Nations are obviously, fraught, and a lot of Americans do not really feel much affection for that body and feel it's really dominated by countries that have interests adverse to ours. With regard to your second point, certainly whenever someone presents a colorable case to a judge, the judge has to decide the case and vindicate the rights of the parties. But my point is first that those rights will often turn on a judgment about facts, about circumstances, about the weights in a balance. And the judges may have profound uncertainty about what those weights are and may not have the knowledge and the skills to evaluate some of the weights. And that is a difficult problem for judges, and sometimes they just take the easy way out and they defer to some judgment made elsewhere in the political system.
Okay, I think we can take maybe just one more question. So, yes.
Judge Professor Posner, I want to get back to just that point about the expertise of various groups within the government, and I think your point is well taken that judges lack the expertise that would allow them to weigh the cost to society in terms of terrorism and whatever else. But it strikes me that it's equally plausible that the executive lacks the necessary knowledge sufficient to allow them to weigh the costs in terms of individual protections, and in particular, given the fact that the executive is elected by the majority, that they would be particularly poorly positioned to understand the costs that are being imposed on minorities. And I was wondering if you could just speak to that point.
Oh, I think you're right. I don't disagree with that.
But I think I would go further, and I don't actually think that any kinds of expert judgments of this sort to be taken seriously in the legal process. And indeed, I think it's precisely the idea of relying upon basic values incorporated in the Constitution, values of liberty and equality, that the enforcement of which do not require expert judgments. And even judgments involving individual self-defense don't require experts. You can't call experts into court to talk about how a reasonable person would respond under the circumstances. That's not a matter for expertise. And I think Posner has a view that somehow costs to liberty can be quantified and compared with the benefits to security. Even apart from Franklin's statement that someone who thinks like this doesn't deserve either security or liberty, I don't think that the process is conceivably rational. You cannot, first of all, assign a cost to the liberty. I don't understand what that means. And secondly, if you could, you wouldn't know exactly what the competing costs were on the other side. And the thought that somehow you can call in expert witnesses who would resolve this is a kind of fantasy.
Of course, the cost can't be quantified, but George, you can't really think, I'm sure, that substantial risks to national security cannot be taken into account in the legal process. I mean, how could that be? That really would make the Bill of Rights a suicide pact. So someone is going to have to weigh these risks, not quantitatively, but they have to be. Most of the judgments we make are not quantitative, but they are balancing the good and the bad of alternative courses of action. to the extent these involve, technological issues and military issues and all sorts of secret information and so on, obviously some weight has to be given to the judgment of the people who make this their life work.
Okay, well, I sense that we could prolong this debate for a very long time. We have a reception that is waiting for you, and we hope that you will all join us. Don't forget the book tables out there, and please join me in thanking the speakers.
I hope it was okay.